Well, good morning, everybody. Good morning. Please take your seats. We're about to begin. We welcome you to New York Law School on this breakfast. The breakfast is sponsored by the Center for New York City Law and by the Center for Real Estate Studies here at New York Law School. Andrew Berman, the chair of that. I'm Ross Sandler, professor and head of the Center for New York City Law, and I welcome you to our new building. Some of you may not have been here before, but this building opened in the fall and has been an enormous success for our students and for the faculty who really enjoyed teaching in this wonderful new state-of-the-art facility. For those of you interested in the building itself, it's 4 down and 5 up. It's a tale of zoning and community involvement. Today we're talking about eminent domain, and we have a little bit different forum for us anyway. We'll have a speaker, Norman Siegel, and then a commentator, Ross Moskowitz, and questions from the floor. All of this in an hour will end exactly at 9:30. We're delighted to have Norman Siegel with us. He has been a major factor in civil liberties and in New York City politics for a very long time. Graduated from NYU Law School in 1968, began working with the ACLU in the South on getting African Americans into the jury pools, worked on later here in getting younger voters to register, worked directly with the American Civil Liberties Union in 1985, became the executive director, and for the next 15 years to 2000, was very much involved in every important issue in civil liberties here in the city, as he confronted the Koch, Dinkins, and Giuliani administration on such issues as what type of art might be hung in the Brooklyn Museum and who might protest and when on the City Hall steps. He ran for public office, then recreated the ACLU as a private practice, and has taken on many cases in that capacity, which has brought him here today on the Columbia University case. Ross Moskowitz will comment after the talk by Norman. Is a partner and has been since 1998 at Strzok & Levan. He came to that position after extensive experience with the government. He was the executive vice president of the Economic Development Corporation, where he was involved with such important projects as Reuters Building and Condé Nast in Times Square. He also was the executive director of the Industrial Development Agency, which funds much of development in the public-private area, and he is an expert in public-private development here in the city. In his private practice today, very much involved with land use, appearing before all New York City land use agencies, and he will be the commenter after Norman's speech. Norman will speak, and then we'll have comments by Ross Moskowitz, and then open mic from the audience. So first, Norman Siegel, we welcome you to New York Law School.
Good morning. It is a pleasure to be here this morning and be given this opportunity to speak to such a distinguished group of New Yorkers about a very critical subject matter, eminent domain. Let me begin by thanking the two Rosses, Ross Moskowitz and Ross Sandler, for inviting me. Ross's opening comment about I went to private practice and recreated the ACLU. I use that line over and over again. Second, I want to thank my client, Nick Sprayragan, and his family for having the courage, the privilege, and most important, the stamina to fight the fight that he and the Sprayragan family are waging. Third, I want to thank my co-counsel, Stephen Hyman and Philip Van Buren, for their lawyering skills, consistency, and commitment to challenge the abuse of eminent domain. And finally, to my wife, the Honorable Sarah Lee Evans, who is here with me this morning, for your support and love. The topic this morning, the use, parenthesis, and misuse, close parenthesis, of eminent domain. I always, when I speak, try to answer the topic question. My answer, as you will hear in the next 30 minutes or so, is that the current use of eminent domain in New York State, in my opinion, is, generally speaking, a misuse of eminent domain. Most of my comments, observations, and experience come from being co-counsel in the cases surrounding the Columbia University expansion plan in West Harlem, and for a short period being co-counsel in the Atlantic Yards cases in Brooklyn. In my comments this morning, I plan, one, to speak generally about eminent domain and make 4 specific recommendations to change New York's eminent domain law, and then 2, speak about the Columbia expansion plan eminent domain case, now scheduled to be argued in New York's Court of Appeals on June 1, 2010. Then listen to Ross with his comments, and then finally, the best part, listening to the questions and comments. And don't disappoint me, this is New York City, where I always like to say it's the town of the big mouths, and therefore, don't be shy. And if I say something that you disagree with, which I'm sure I will be saying many of things that you'll disagree with, go to the mic and take me on. It's more entertaining and more enjoyable. Don't be boring. So let me begin. When we were growing up, and for me, that's the 1950s and the 1960s, it's Brooklyn, it's the public schools, and it's Brooklyn College. We were taught that our Constitution prohibits the government from taking private property in the name of eminent domain, except if it is for public use, such as a public highway. But that turned out to be incorrect. Today, under the concept of eminent domain, the government takes private property and transfers the property to a private entity if it is intended for a public use, a public purpose, or a public benefit. Removing, quote, blight, unquote, or enhancing economic development is now also a proper ground for the employment of eminent domain. Almost 5 years ago, when the Supreme Court of the United States in the New London, Connecticut case, Kelo versus the City of New York, held that it was constitutional to take property by eminent domain for economic development, it caused a firestorm all across America. Eminent domain became a widely discussed, controversial, and divisive subject. As then Justice Sandra O'Connor wrote in her dissent, quote, "The specter of condemnation hangs over all property. Nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping mall, or any farm with a factory." In New York City, the eminent domain controversy has recently played out in communities of Atlantic Yards in Brooklyn, West Harlem and Manhattan, and as you see in the New York Times this morning, Willets Point, Queens. Looking forward, here are a few recommendations for change in New York's eminent domain laws that the state, the city, private developers, private property owners, community residents, and elected officials should, in my opinion, consider. 1, currently the government can seize private property if an area is blighted, legally defined as, quote, substandard or insanitary. A law that defines this condition, in my opinion, is vague, leaving private property owners in a quandary, not knowing what substandard or insanitary means. Vagueness invites subjectivity. Subjectivity invites selective enforcement. Selective enforcement invites favoritism, and that's no good. The state legislature needs to hold public hearings to elicit public comment so that it can better draft laws clearly spelling out what constitutes blight in the context of the use of eminent domain. Legally speaking, and I'm not going to bore everybody with the case sites, but whenever I say quote and then some words, that comes from a case. If anybody wants the sites afterwards, I'll hang around and give you the sites. Quote, civil as well as penal statutes can be tested for vagueness under due process clause. Due process requires that a statute be sufficiently definitive, quote, so that individuals of ordinary intelligence are not focused to guess at the meaning of statutory terms. Quote, to this end, nothing less than adequate warning of what the law requires will do. After the Supreme Court's decision in the summer of 2005 in Kelo, state courts have now focused renewed attention on the broad scope of blight statutes. In Norwood versus Horney in 2006, the Ohio Supreme Court found the statute authorizing the use of eminent domain in language similar to our law in New York void for vagueness on its face when it defined blight as a, quote, deteriorated or deteriorating area. Those words are in our statute. The court found that property owners did not have fair notice of what conditions constituted a deteriorating area. Vagueness in the definition of blight offends the constitutional value of preventing arbitrary and discriminatory application of the law. The requirement of notice through specificity is, quote, not only to ensure that citizens can conform their conduct to the dictates of law, but equally important, to guide those who must administer the law, end of quote. In the context of eminent domain, unfettered discretion enables takings that are motivated by favoritism. With unfettered discretion, the condemning agency can pronounce any area blighted when really the area's chief characteristic is its attractiveness to the favored developer. A vague standard of blight permits and encourages discrimination, in my opinion, in favor of the developer over the existing community, local businesses, and current property owners. As the Ohio Supreme Court put it, quote, rather than affording fair notice to the property owner, the Norwood Code merely recites a host of subjective factors that invite ad hoc and selective enforcement, a danger made more real by the malleable nature of the public benefit requirement. We must be vigilant in ensuring that so great a power as eminent domain, which historically has been used in areas where the most marginalized groups live, is not abused. That quote, taking out the Norwood Code and putting the UDCA instead, would be very applicable to New York. Second, one of the factors taken into account in categorizing an area as blighted is the element of utilization. If government determines that an area is underutilized or that it is not being used up to its optimal use, it weighs this as a factor in finding blight, sometimes regardless of the character of the community. This, in my opinion, makes no sense. Moreover, in my opinion, a private property owner has the inalienable right to determine the best cost of the productivity of her or his property. It is a right, in my opinion, that should not be ceded to any government. In the Columbia eminent domain case, underutilization was one of the factors that the consultant used to find that Manhattanville industrial area, the project site, generally from 125 to 133, from Broadway to 12th, was, quote, substandard and insanitary. Underutilization is normally understood as an indicator of blight because it reflects depressed economic conditions or reflects the presence of some other condition that makes it impossible for the owners to make profitable use of the full development rights to which they are entitled under the zoning law. In the Columbia situation, the consultants used an arbitrary standard of counting any lot built to 60% or less, the maximum allowable under the FAR, as underutilized. This allowed it to designate some of the properties, the lots in the area, as substandard and insanitary solely on that basis. The consultants, however, offered no rational basis for the use of this criteria in the context of Manhattanville, which was zoned as FAR 2, much less for its use of the 60% figure. For example, the city's City Planning Commission uses 50%. When we countered the blight statements that were put in by 3 consultants, we created our own blight study called the No Blight Study. We used 40%. So right there is the point that I'm making about the arbitrary nature of figuring out what standard to be used. And the standard will create the result, as I will explain in a minute. A 60% standard in an area zone for a maximum floor area ratio of 2 effectively means that a single-story structure is categorically blighted. If you have a FAR of 2 and you use 60%, the math, 60% of 2 is tellingly 1.2. If you use 50%, it would be 1. If you used our 40% that we used, it would be 0.8. So when they chose 60%, which was just out of the air in our opinion, it created the result that any building, for example, the gas station, 1 story, good condition, financially doing well, by using that methodology, that gas station and any other 1-story building in a FAR of 2 is categorically blighted. That seems to me wrong. The difference between the consultant's 60% standard and, for example, our no blight study standard of 40% amounts to the difference between their 60%, meaning 39% of the area was underutilized, compared if you use the 40%, just 20% of the area, so almost double. In an area with a maximum FAR of 2, there is little to be gained, I submit, in tearing down a 1-story building in profitable use to build a 2-story building. And in Manhattanville, the prior low-rise zoning of the area, because it recently got changed from 2 to 6, and I'll get to that in a second, that 2, with the 39% that they used as a result of the 60%, I submit is not blight, but a deliberate policy choice to preserve for the benefit of the wider city economy the character and customary uses of the area. It was zoned for a 2 for specific policy reasons. And because of that zoning decision, you can't, I submit, therefore conclude that every building that's 1 story in a FAR of 2 is categorically blighted. So what's my recommendation here? It's that New York should eliminate the use of eminent domain based exclusively on the use of underutilization. Or alternatively, at a minimum, New York should establish uniform rules that provide a basis to determine whether or not property is being utilized. Third, the current process to challenge eminent domain findings, I submit, is unfair and unconstitutional. Generally speaking, when a New Yorker goes to court to challenge government action, she or he goes to a trial court. If I'm going to file a lawsuit this afternoon for someone in New York, constitutionally, statutorily, you go to the trial court. You go to a Supreme Court in the county, or you go to the federal court in the Eastern or the Southern District. Challenges to the employment of eminent domain followed this procedure. You go to a trial court until 1977, when the New York State Legislature changed the law. Currently, a private property owner, the condemnee, must begin the challenge to eminent domain taking in an appellate court. It appears that New York is the only state in the country, it appears, that employs a scheme that bypasses the trial court. One of the serious weaknesses in the process is that the petitioner has no right to discovery, or cross-examine the developer's allegations about the specifics of the project, including, most importantly, as a result of Kelo and economic development, the promises of job creations or generating tax revenue. Moreover, by not allowing review by a trial court with the judicial resources to evaluate an extensive record, sufficient time for a full hearing of complex issues, and the right to a jury trial, the EDPL, the Eminent Domain Procedure Law of New York, in my opinion, violates the condemnee's right to due process of law. Don't get me wrong. When I argued in the appellate division and the red light went on, they allowed me to go on. But we were given 15 minutes. I can't even make this speech in 15 minutes. And most of you in the room, if you're lawyers or lawyers-to-be, you know what I'm talking about. It just makes no sense that you have a complex, our record, 18,000 pages. The brief we just filed in the Court of Appeals, 151 pages, 346 footnotes. You can't do it in 15 minutes. In a trial court, you got the time to develop your record and make your points. This aspect of the system in New York needs to be changed, and changed quickly. If we talk about fairness, how can you have it beginning in the appellate court? As good as the appellate court is and was, we won there. I don't want anyone in the appellate division, First Department, especially Justice Catterson and Nardelli and Richter, to think I'm criticizing you. I appreciate your decision last December, but systemically speaking, there's something wrong about that system. And when you look at the legislative history of why we changed, it is particularly troubling. But I don't have enough time to go into that at this point. And fourth, the government agencies such as the Empire State Development Corporation that are involved in eminent domain cases should be prohibited from retaining consultants who are simultaneously consultants to the developers who are petitioning, requesting the approval of projects pending before that agency. This practice is a quintessential conflict of interest and taints the entire process, and as I will explain in a couple of minutes, it happened in the Columbia expansion plan. Since the infamous Kelo versus New London Supreme Court decision, 43 states have changed their eminent domain laws to provide greater protections for private property owners from abusive government action. New York has not made any changes. It's time for New York to wake up and to act. And now, with the time remaining, let me talk about Tuck It Away and Carr versus ESDC. This case concerns a challenge to the Empire State Development Corporation's adoption of a plan to use eminent domain to take family businesses and transfer their property to Columbia University to help create a new 17-acre campus in West Harlem. On January 20th, 2009, a little more than a year ago, Tuck It Away and the Carrs filed petitions with the Appellate Division, First Department on 25th and Madison. Pursuant to the eminent domain procedure law, they opposed the use of eminent domain in the Columbia Plan. I'm pleased to say on December 3rd, 2009, the petitions were granted. The Tuck It Away petitioners represent a family-owned business that has been in Manhattanville since 1980, expanding to 5 of the larger buildings in the area to meet the growing demand of self-storage and moving services for cramped Manhattan residents and businesses. Tuck It Away is also the landlord to large retail stores that serve that community. The Carr petitioners represent another long-established business in the neighborhood who have been operating 2 gas stations since 1985, which constitute the life savings and sole occupation of a hard-working immigrant family. Both have made long-term investments in the neighborhood, contributing to the steady employment and vital local services the neighborhood has provided to the West Side and West Harlem communities. The Tuck It Away and Carr petitions allege that the ESDC exceeded its statutory authority and acted unconstitutionally by finding that the area was blighted in bad faith, and as such, the alleged public purpose of remediating blight was a pretext for a pre-existing policy commitment to give the entire area to Columbia University. The petition is alleged that ESDC only later, after they added the designation of the project as a civic project, in addition to the land improvement project, as a further pretext, unlawfully construing a private university as a civic purpose and adding a package of civic benefits that were either already required to mitigate environmental impacts that did not substantially relate to the facilities proposed to be built or inured principally to Columbia's benefit. The petition is further alleged by undertaking the project at Columbia's behest, defining the project exclusively around Columbia's needs without any prior public determination of a public purpose for the use of eminent domain, and in contravention of the prior public planning that was undertaken. The Columbia plan constituted an unconstitutional taking under Kelo. The petition also alleged the term and insanitary or blighted was unconstitutionally void for vagueness for the reasons that I mentioned earlier. Tuck It Away additionally alleged that their statutory right to be heard and their constitutional right to due process had been violated when the ESDC closed the hearing record while continuing to withhold records that they had sought under New York's Freedom of Information law, and that two courts had ordered them to release these records. And both groups of petitioners alleged that the EDPL violated due process of law by the point that I made before, giving original jurisdiction exclusively to the appellate rather than the trial court. Now, the Appellate Division First Department annulled on December 3, 2009, ESD's determination and findings on the ground that the ESDC violated the petitioner's constitutional and statutory right to be heard. We used FOIL, and I'll get to that in a second, perhaps unique in the cases dealing with eminent domain. I determined after reading 50 years of case law in New York about eminent domain, the pattern very often was petitioner alleges bad faith. However, the record does not substantiate that allegation. So what does a good lawyer do? A good lawyer learns very quickly, create your own record. And that's what we did. In addition to the 8,000 pieces of paper that the state put in, we put in about 10,000 pieces of paper. We used FOIL to get the emails, the minutes of the meetings, who attended the meetings, the correspondence under FOIL, which citizens are allowed to use. And that created the record that makes our case, in my opinion, unique, because we can substantiate clear bad faith in how this process took place over a period of 6 years. The due process analysis of Justice Richter, in her concurring opinion, Catterson and Nardelli, then there's Richter with her concurring opinion, and I forgot the judges, Tom and one other who dissented. So it was on the due process issue 3-2, which gives the ESDC an automatic right to go to the Court of Appeals. Richter's concurring opinion depended on, quote, the confluence of factors here, including the evidence raising questions of bad faith and pretext. The opinion of Catterson, with Nardelli joining, went much further. Catterson found the evidence in the record persuasive and annulled the ESDC's determination and findings on the ground of bad faith and pretext, as well as for the due process and procedural violation. Catterson and Nardelli found ESDC overstepped its statutory authority when it cooperated with the private beneficiary Columbia in generating a basis for finding blight, when it retained Columbia's consultant, Alley King, Rosen, and Fleming, known as AKRF, to find such blight, and when it cooperated with the consultant to produce a study that was biased in fact. The two justices found that the application of the terms substandard and insanitary was unconstitutionally vague as applied. And they also found that the ESDC's subsequent attempt to invoke an alternative authority under the law and call the Columbia Plan a civic project was legally insufficient and a pretext for policy already established in favoring Columbia as the sole developer of Manhattanville. Catterson and Nardelli consequently found the taking unconstitutional in accordance with Kelo. Some people say, well, Kelo was about economic development. It was about the federal Constitution, and it doesn't have any application to eminent domain. If you make that argument, I think you're going to find yourself on very thin ice, and the ice will crack very quickly. Our case needs to be distinguished from the Atlantic Yards case, where in November of 2009, the Court of Appeals upheld the Atlantic Yards project in Brooklyn. More and more people ask me, well, how do you distinguish it? And isn't the Court of Appeals going to basically use Goldstein to reverse the appellate division? I don't think that's what's going to happen. In that case, the court recognized that, quote, there remains a hypothetical case in which we might intervene to prevent an urban redevelopment condemnation on public use grounds where the physical conditions of an area might be such that it would be irrational and baseless to call it substandard and insanitary. Well, when I'm up there on June 1, I will respectfully submit to the court that the Tuck-It-Away car case is exactly that hypothetical case. We submit that Tuck-It-Away car is not about a difference of opinion. And Goldstein, the Court of Appeals, talked about, well, the arguments on both sides, it's merely a difference of opinion. And it's not for the court to jump in on that issue. I don't know why they all of a sudden on issues of eminent domain think that they should be holding back. Ever since Baker versus Carr in the early 60s, the whole issue of courts being involved in issues has expanded, and we will hope that we could move them away from the deferential role that courts historically have played in New York with regard to eminent domain cases. There's no reason why they should be silent on these issues and should be looking at the record to determine whether there's substantial evidence to support the findings of government agencies, especially in the area where you're taking someone's home or their business, which is a fundamental right. For example, in Manhattanville, as opposed to Brooklyn, there was no prior legal designation of an urban renewal area and no de facto blight conditions such as a rail yard that they had in Brooklyn. To the extent, and this is the controversial part, I guess, any conditions that were documented that could conceivably indicative of blight, we submit that such things as vacancy and limited building conditions, these were maintained, exacerbated, or caused by Columbia with ESDC's knowledge. Columbia started purchasing property in the year 2000, and the blight studies were not published until July of 2008. And again, when the consultants for the state determined, for example, that there was vacancies in the buildings. Well, vacancy for blight came about in the 60s when people were leaving the inner cities to go to the suburbs. And that was a choice that people made to get out of the inner cities for various reasons, to go to the suburbs, and you had a voluntary vacancy. And the vacancies, for example, of the 18 buildings that the consultants found that were vacant, 17 of them were owned by Columbia. And we demonstrated that within 2 years, from that period that Columbia was purchasing property, within 2 years, those buildings that were filled with businesses, in 2 years they were gone. And there's a pattern. Signs for rent with a phone number. So we called those numbers. There were no answers. One lawyer called, he finally got through to someone to make inquiry about renting the property. And the person on the other line, an affidavit in the record, said, we're not renting the space. So the question, bad faith, were those signs for rent, a ruse? And in fact, was this whole plan to use things like vacancy, a plan to create the factors that would allow someone to argue that the neighborhood was blighted. And if we're right, that is bad faith. And then let's talk about the consultant. In our case, the government hires Columbia's consultant to find the basis for blight, which two courts concluded was a conflict of interest and likely to be biased. Those cases came as a result of our FOIL cases, where the government refused to give us any correspondence, any documents with the consultant, arguing that the consultant was the equivalent of an employee for the government agency. But we found a case in the Supreme Court that said that when the consultant has an interest, then they are not, for FOIA purposes, to be exempt from disclosure. And so we won those cases, and the court said that in this situation, those documents should be disclosed because of the interest that the consultant had. So you step back for a second and think about that dynamic, that the government is going to choose a consultant to determine whether a neighborhood is blighted. Very important for the purposes of eminent domain. And they choose the consultant who's the consultant for, in effect, the developer. Isn't there something wrong with that? That's one of my recommendations, that they should not be hiring, the government should not be hiring the consultant for the developer. New York courts have in the past, especially New York courts, given wide latitude to government agency discretion in the use of eminent domain. But at some point, an outer limit must be defined, so not any area may be called blighted, or not any project may be called a civic project. And we submit that the government's actions in the Columbia expansion plan exceed that threshold limit. What's my time? I'm seeing I should cut it. There's a lot more that I'd want to say, but in view of the time, let me just conclude by also making the point that neither the ESDC or Columbia have ever made an offer to tuck it away, and they have not responded to Tuck It Away's offers for a land swap or long-term lease. Tuck It Away owns property on the west side of Broadway. Columbia owns property on the east side of Broadway. An offer was made to resolve this amicably, make a swap. Columbia and ESDC have not responded to that, and although Columbia did make an offer to the CRES property, the offer was extremely undervalued, the worth of the properties, and Columbia did not respond to the CRES offer for a property swap as well. So it's on to Albany on June 1. We're, of course, pleased with the appellate division decision, and we're cautiously optimistic that we will prevail in the New York Court of Appeals. I think that there's a lot that people in this room, as well as people throughout the city and the state, need to take a new look, a hard look, or at least a look, at the EDPL, and to take into consideration some of the factors that I have mentioned this morning, as well as if I had more time, I could go on and on and on. I think in my years of being a lawyer, which is now almost actually just 4 decades, I've been involved in a lot of cases that deal with abusive conduct by government officials. And in the area of eminent domain, there needs to be a lot of change. There's a lot of anger out there. There's a lot of cynicism about government and government officials and who they favor and the disproportionate impact that this has on people of color and poor people. And if all of us care about a just society and to make sure that government is not abusing their rights, we need to look at the issue of eminent domain because, in my opinion, it is a 21st century civil rights issue. I thank you for listening, and I look forward to your comments and criticisms. Thank you very much.
Thank you for a very clear and full explanation of the case and of the positions on eminent domain. Ross Moskowitz, come on up. Now for comment.
Thank you, Ross. It's a pleasure to be here amongst distinguished faculty, alumni, and other guests. It's also a pleasure to be able to participate in this important public policy discussion with Norman Siegel, someone whom I respect, invited, and who I actually work alongside. Last night, I had the pleasure of watching my favorite show with my 14-year-old, Gossip Girl, of course. And in between commercials, she said, "So what are you doing tomorrow?" I said, "Well, I'm giving a speech on eminent domain." Couldn't believe it. She actually went online and started Googling. She's like, "Who's this guy Norman Siegel that keeps showing up? He's showing up everywhere." I said, "Well, he's actually going to be participating too." And she starts reading Norman's bio online, because it's online, and it's still a commercial. And she says, "Do you see what he's done?" I said, "Yeah, he's participated in a lot of really good stuff." She's like, "You're going, which side of the issue are you on?" I said, "I'm going to take a little different approach than Norman." She's like, "Are you sure you want to do that?" I said, "Yeah, I'm good with that." She's like, "But do you see what his bio says, Dad? He ran for public office, like the whole city, Dad." Oh, wait, Gossip Girl's back on. I'll talk to you later, Dad.
I think she has her priorities correct.
You know, my lead here is what I hope Norman would say, in that he is quoted as saying, and he said it again today, that eminent domain reform is the civil rights issue of the 21st century. Now, others have suggested that government should concentrate on infrastructural investments such as streets, parks, schools, and facilitating commercial enterprises that are inherently speculative are probably a speculative sum game. Though these are valid points and certainly misapplication by government, whether in the context of property rights or in its use of police powers, should not be misused. However, I would suggest, and I'm going to pause, I would suggest that this is not a constitutional issue, but rather is an issue of economic development, thin ice and all, and political decision-making. Eminent domain may be a power that people love to hate, but it's also one that communities that are serious about planning are rightly reluctant to resist and restrict. As a legal matter, the legislature says the government can only take private property for public use, but more than a century of precedent interprets that requirement to mean that government may use eminent domain for a public purpose. Just as government took private property to promote private railroads a century ago, it has done so in recent decades to promote commercial redevelopment to revitalize urban areas, such as Inner Harbor in Baltimore and closer to home here, 42nd Street and Times Square. Now, many New Yorkers have heard about Kelo and the legislature's discussion of the issue, especially in light of the decisions that Norman has outlined. Their first assumption is that eminent domain is used to take away people's homes. They don't think about what is generally the use of eminent domain, which is to acquire property that is vacant or run down or that has been contaminated by some former industrial use. They don't think about property owned by absentee landlords who won't invest in their property, despite considerable efforts by local governments to bring about code enforcement. These are all uses of eminent domain to take care of community-based problems, where if people only knew in the circumstances, they wouldn't think eminent domain was such a bad tool after all. But because the public naturally fears for their own property, they don't understand that it's very seldom used for residential property and is more often used for problem properties. I would also suggest that a majority don't understand that eminent domain is seldom used for redevelopment. Out of the many properties that redevelopment agencies acquire, the overwhelming number of them are acquired through negotiated purchases. Only a very few, very well known, only very few, however, go to a decision by a court resulting in a final eminent domain action. Putting aside the Kelo case, let's answer three practical questions here. When, if ever, is eminent domain proper? Second, is it ever proper when the private property taken is going to be transferred to another private entity rather than being kept by the government for some governmental use? And three, is the power granted local municipalities by the Kelo decision likely to be abused? Generally, government should be required to buy the property it wants in the open market like anyone else. When the government does take property by eminent domain, it has to pay the owner the market value of the property. The justification for eminent domain, however, is that sometimes a landowner may be in a position to exercise holdout power, enabling him or her to obtain a monopoly rent in the absence of an eminent domain right. The clearest example of this is that of a railroad company, which we know will provide service between 2 points and needs an easement from every single one of the intervening landowners. Knowing this, each landowner has an incentive to hang back, refusing to sell to the railroad except for an exorbitant price. Each hopes to be the last holdout after the company has purchased an easement from every other landowner, easements that will be worthless if it doesn't obtain an easement from that last holdout. Railroad or other right-of-way companies are not the only private enterprises that can make an argument for the use of eminent domain power. The argument is available in other cases in which a large number of separately owned contiguous parcels have to be acquired for a project that will create greater value than the parcels generate in their present use. In order to avoid misuse, area-wide development projects under state laws that govern them are subject to onerous, transparent, and lengthy processes that provide all the details of the project and invite public participation and extensive debate. In Kelo, the public was asked what it thought about the redevelopment project, as the project was debated, shaped, and decided for a period of nearly 2 years. Here in New York, under the State Environmental Quality Review Act, redevelopment projects generate foot-high environmental impact statements that include a hard look at their impact on a community, character, and neighborhood change, and contain lengthy chapters on the economic and environmental consequences of the project. Public hearings, ULURP proceedings in New York City, reviews of impact statements, open meetings laws, conflict of interest rules, and a host of other legal protections ensure that the public knows who is involved, how they were chosen, what the proposed benefits are, and who will suffer. By the time such projects are approved, the public process has mediated the claims of those whose properties are to be taken and the public benefits of urban revitalization, jobs, housing, increased taxes, better services, and a more livable community. The many state legislative reforms that followed Kelo's discontents are divided into 2 categories. The first includes those that affect needed procedural and substantive reforms, such as longer notice to affected landowners, more public involvement, more transparency, better area-wide planning, or a clear articulation of the public benefits to be achieved. The second curtailed the use of eminent domain in one of several ways. Some states limit it to public works, or to public access, or to public utility projects. Allow it in blighted areas, but narrowly define what blighted means. Prohibit it for economic development. Prohibit the transfer of condemned land to private developers, or some combination of these. I would suggest there are serious doubts about whether the consequences of this second category of reforms are beneficial. If New York statute, for example, were to limit condemnation to public work projects, or limit it to use in narrowly defined blighted areas, New York City would have a great difficulty carrying out area-wide development projects such as they did in 42nd Street. In response to these decisions recently by the New York State Court, in Atlantic Yards and Columbia University, the legislature has proposed a number of amendments to the existing domain law in the state. There are 3 key provisions I'd like to highlight. 1, an increase in the time frame for appeals of decisions to condemn by condemning authorities to 90 days. It's currently 30 days. Second, the provision of additional protection for displaced property owners. And 3, and most controversial, the empowerment of the local legislative bodies by providing such bodies with the authority to approve or disapprove a decision to exercise the power of eminent domain by a condemning authority. Now, this Reform Act is intended to provide additional protection for these displaced property owners by requiring that where economic development is the purpose of the condemnation, the condemning authority must prepare a comprehensive economic development plan for the area, and that plan must include the expected increases in tax revenue or expected creation of jobs, the types of future businesses intended for the affected area, and alternatives to this plan. This process requires coordination with the local government in which the affected area is located and must include public hearings. To move forward with such condemnation, the local body must approve the economic development plan. Furthermore, the Act places a statutory minimum for compensation at a rate that is 150% of the fair market value of the homes to be condemned. I would suggest, even if this legislation is likely to evolve over time, it would represent a significant change in eminent domain law in New York State. It would afford property owners and the public significant additional protection and would provide broad access to relevant information. I would suggest that many of these changes impose unnecessary restrictions, however, on the use of eminent domain powers, which in the end could thwart much-needed economic development efforts, thereby hurting the very public that legislation is intended to protect. Among the concerns are that local governments, which under the legislation would have the power to approve or disapprove the condemning authority's determination on the exercise of eminent domain powers, and these locals may lack the resources or the expertise to make such decisions. Consequently, such decisions may be significantly delayed or inappropriately disapproved. Additionally, there should be concern that the criteria for finding of blight may be so stringent, both substantively and procedurally, that the condemning authority may not be able to utilize such powers, even when such exercise would benefit the property owners and the public generally. Finally, the dual role of the ombudsman under the proposed legislation, to advise the public generally and to assist state or local government in analyzing potential actions, may involve inherent conflicts of interest that could be problematic in some instances. Before corrective legislation is enacted in New York, there is more that we need to know about the use of condemnation and redevelopment. How much actual hardship is caused to those whose homes and properties are condemned? Anecdotal evidence shows that most affected owners settle, agree on prices, and relocate. Do we know whether redevelopment projects would be feasible without the availability of condemnation? Again, there is evidence that many property owners would fail to negotiate for a fair settlement with redevelopment agencies if they didn't realize that the agency could take their property if negotiations fail. If the absence of the power of condemnation would mean that most redevelopment projects would not be feasible, what are the resulting costs to the public? So what does this all mean? The reality is that eminent domain has concrete, real benefits. 1, assembling land for redevelopment helps to revitalize local economy, create much-needed jobs, and generate revenues that enable cities to provide essential services. 2, when used prudently and in the sunshine of public scrutiny, eminent domain helps achieve a greater public good that benefits the entire community. 3, if eminent domain for economic development is prohibited, one person could veto the redevelopment of an entire distressed community. This would have the practical effect of making such projects virtually impossible. And 4th, unduly constraining eminent domain would thwart job creation by eliminating an entire category of projects from the redevelopment toolbox of local officials. Thank you.
Okay, we're not great at time management here. There was no red light, so we're a little bit, we have at least 10 minutes and maybe more for questions and comments. What I'd ask is comments to be relatively short questions, address it to either Norman Siegel or Ross Moskowitz, and go to the microphone so everybody can hear you. And as well, this is being broadcast live on our website and will also be librated on our website. So start off here.
My name is Rick Landman. I was the Executive Director of Real Estate Development for the Division of Real Property for the city in the 70s. My question deals, one, for Norman, for timeliness. The city condemned numerous properties for urban renewal in the 60s and the 50s, like down by Chambers Street, Beekman Hospital, and basically land banked them for 40 years, upzoned them from a manufacturing with an FAR of 5 to a C6 with an FAR of 7.5, removed deed restrictions for not-for-profit health organizations so that they could be sold for profit-making high-rise luxury buildings. What happens if the public purpose, public use, public benefit totally is ignored for 40 years, and then, you know, you get the Palm Restaurant and, you know, Frank Gehry's building where you were supposed to be getting, you know, a hospital and low-income housing?
It's a good question, and it's popping up in a couple of places on the Upper West Side with Fordham University, that 40-year period. One, perhaps now, because of Kelo, if that kind of government action occurred, communities would be sophisticated enough to go in and challenge it at the early stage. If you wait the 40-year period, legally there could be real problems there. I think Kelo woke people up. A lot of people were not focused on eminent domain, and I think communities now are beginning to organize. I respectfully disagree with some of Ross's comments about the negative aspects of people beginning to challenge eminent domain. And when you give those kinds of examples, it troubles me that the government was able to get away with what they're doing. If they, in fact, followed through with actual public use, public benefit, and public purposes, as opposed to, as Sandra O'Connor said, taking it and using the example of taking it from Motel 6 to do it Ritz-Carlton, I think Americans and New Yorkers think that that's wrong.
Mr. Siegel, Brian Logan from Bryan Stratton College. Has there been any attempt to make a community benefits agreement to force Columbia or the Empire State Development Corporation to put in certain things like they did at Yankee Stadium?
Don't get me going on Yankee Stadium. I do have to admit I'm an old Brooklyn Dodger fan, so I sometimes think my comments about Yankees and Yankee Stadium is biased. There was an attempt to do a community benefits agreement, and it did not work. And then they created unilaterally a memorandum of understanding, and there's a long list of, quote, civic benefits, unquote, that we believe are pretextual. It's very possible that the Columbia plan all along, as Justice Catterson pointed out, was really about economic development and to benefit Columbia. But when Kelo came down, especially with Kennedy's concurring opinion, setting forth the 7 factors that he concluded made the process and the result in New London not favoritism, and therefore he went with the 4 in Stevens' opinion. When you apply those 7 factors to the process that the city and the state and Columbia used, they're in trouble. And so the decision comes out in the summer of '05, and then all of a sudden, in '06, it's not just a land improvement use project anymore. It's now, quote, a civic project. There's serious legal questions about whether or not you can have a civic project for a private university when a civic project, basically on the case law, means that it has to be accessible and open to the public. A private university can set whatever admission policies it wants, and so there's all kinds of questions about that. And in the context of that, it's possible that they decided that they come up with a community benefits agreement to put some, what I call, goodies on the table and try to increase their argument about public benefits. It didn't work. The community and the people who were involved in that process didn't go along with that. And the result is that the civic project argument, at least the 2 in the plurality, the appellate division, did not buy into that. We'll see what the Court of Appeals has to say on that. And finally, I want to point out that the Association for the Bar of the City of New York recently put out a statement being very critical.
Actually, a report.
Report.
I'm the co-author on that.
That's correct. Well, I commend you for the report. And people should read it because it raises serious and substantial questions about whether or not community benefit agreements should enter into weighing whether or not, when you're doing at least eminent domain, that should come into the picture.
Judy Richheimer. Mr. Moskowitz, a perfectly nice large-scale project got built in the 30s called Rockefeller Center. And there were 2 holdouts, but the project got built nevertheless. And the holdouts create charming footnotes for tour guides to talk about, and life went on. So I'd like you to comment on that. And for Norman, you are a man of the left as well as a civil libertarian. The 2 are not necessarily synonymous. And as someone who identifies with both of those schools of thought myself, I wonder, why is it that we have had such a hard time getting traction in the left, on the left, to have discussion about eminent domain? Why don't progressives and leftists feel that this is our issue as well as an issue for the right? Thank you.
You gave me a very complicated question, I see. I think that not knowing much about the specific holdouts, it does happen. And sometimes you can actually build around the situation. Absolutely. I'm not suggesting that you can't, but this is a bigger policy discussion than that.
First, I wanted to make a disclaimer. I don't think I'm a person of the left. I think
You're
I'm...
sitting on the left.
No, I could... It's on your left. Thank you, Judy. First of all, I'm right-handed. Second, I've always believed, and it's one of the problems with the American Civil Liberties Union today, I am a neutral principle person. I don't make decisions on cases when I was at the Civil Liberties Union based on someone's politics. When the Klan was being denied the right to demonstrate by the Giuliani administration, I went to court, got picketed, death threats. When the right to lifers were being told they couldn't be picketing in front of abortion clinics, I'm pro-choice, but they have a right to demonstrate. And too often today, including at the ACLU, people have lost their way and make decisions ideologically. So I don't think I'm a person of the left. Maybe my neutral principles wind up where the perception is that I'm supporting people on the left, but that's not my process. Second, with regard to a very good question, when you take a look at the breakdown on Kelo, the liberals were approving eminent domain and the conservatives were opposing it. My feeling was, and even when I was at the ACLU, people didn't believe in property rights. They believed in economic rights, they believed in social, political rights, but not property rights. I believed in property rights as well. I think people have a right to own property and that the government can't abuse their fundamental right for property rights. So in the context, liberals and progressive, to use your term, Judy, I never know where that line is when a liberal becomes a progressive or vice versa, but they generally believe in a philosophy that government is good for people. Conservatives, especially libertarians, believe that government is engaged in abusive behavior. A lot of this fight is now taking place all across the country. People with the Tea Party people misconstrue who the Tea Party people are, in my opinion. And in the context of that, the liberals will wind up thinking, and some of Ross's comments, that it's good for the government to do what they're doing and to take someone's property for the good of humankind. Whereas the libertarian instinctively distrusts government, and that's why perhaps in your categorization the right is against eminent domain and the left is for eminent domain. I think that's too simplistic, and I think that what we have to do is try to explain to people the importance of the fundamental right to own private property and for the government not to abuse that right. I have no problem, Ross, if in fact there's real public use, if there's real public benefits and real public purpose. I'm against pretext, because pretext is basically the government pulling the wool over the people. And the reason why there's so much anger and distrust locally and nationally right now is because people believe that government is abusing people's rights and not being forthright with people. And the pretext stuff, and especially on the Columbia case and even Atlantic Yards, the government favors certain developers, and they then hire the various lobbyists and lawyers in order to manipulate the methodology, the facts, to get the result that they want. I'm hoping not only do I win for my client, but I also win so that it becomes a model for people all across not just the state, but around the country to fight back this kind of abuse of eminent domain, which is unfortunately symptomatic of some of the government's abuse in other areas in disregarding and taking for granted people's rights.
We're a little over time. We're going to take these last two questions.
Hello, my name is Maximilian Travis. I'm a student at New York Law School. I heard that the property in Kelo has still not been used the way the city was intending to use it. How do we assure that the economic forecasts are true and will actually go the way they say they will?
It's an excellent question, and let's look at why it's not being used. Pfizer decided not to do the project, right? So there are a couple of things there. One is because of the controversy and because of the delays, Pfizer ended up pulling out of the project. So I would suggest that part of the reason that project isn't happening is because of the community outcry. That's not necessarily a bad thing. I would also suggest that the officials in New London could have actually done a better deal. They could have actually done something that would have put more bells and whistles so that if Pfizer wanted to pull out of that project, New York in particular, there are things such as clawbacks, recapture, there are a series of programs and benefits that Pfizer was going to get if they did that project. They were able to pull out of that project without any penalty. I would suggest that the New London economic development officials should have bargained harder and should have put more restrictions on, so it was not so easy for them to just pull up and leave.
Well, it's not just Pfizer New London. You take the Poletown case out of Michigan, where GM in the early 80s wanted to have a Cadillac plant, and so they got rid of businesses and residential homes, et cetera. And to the credit of the Michigan Supreme Court, 25 years later, in the summer of 2005, the court reversed itself and said basically that the representations with regard to jobs and taxes turned out to be illusory. I think, and what Ross touched upon with some of the proposed legislation, that there needs to be upfront some hard grilling with regard to the representations, with regard to jobs, and with regard to tax revenue. And I think there has to be some standard, and the courts need to be not unwilling to look at the record to determine whether or not those representations are accurate. And then second, some of the suggestions Ross just made could be employed to try to create that kind of dynamic. But the reality, especially in this economic situation where the developers come in and promise the sky, that has to be looked at with some skepticism.
Last question.
Hi, my name is Michael Huber. I'm a first-year law student here. Mr. Moskowitz, I'm not sure if you were in favor of Columbia's plan or if you see any positive aspects of their plan, but if you are, could you please articulate on your 4 conclusions, which include the jobs, revitalization, and a public good, and see how they apply to the Columbia situation?
I am not positioned one way or the other on the Columbia plan. I am not as familiar with the case as Norman is, but generally speaking, I am in, as you can tell from my comments today, I am in favor of eminent domain under the right circumstances. I think overall what Columbia is looking to do, it's a institution, educational institution, research and development, so I think overall there's a general public good for the community. I can't tell you under this plan and under this circumstances whether what Norman has put into his papers and what the appellate division has already said is accurate or not. I think there was perhaps some missteps. Interestingly enough, from what I have gleaned from the papers, newspapers that is, as well as what I'm listening to Norman today, a lot of what was discussed and debated and decided against the Columbia plan and the eminent domain was on process. Norman went to great lengths to talk about all the FOIA requests that were required in order to get information. So, I mean, I think if you break it down between substance and process, I mean, Norman may disagree. I think some of the things that may have come up in the Columbia case, I don't even have to look, right? He's shaking his head, right? Right. We're more on process than on substance.
Let me just add, Columbia owns...
Let me just breathe.
Oh,
Okay, good. Okay.
Columbia currently owns 76% of the project site. The City of New York owns 15% and can transfer it like that to Columbia, which I think they intend to do, giving Columbia 91% of the 17-acre area. We teach our children and grandchildren that you can't get everything that you want. If you get 91% of what you want, that's a pretty good deal. And the question becomes of the areas, there's only one, well, let me leave that alone for the moment. This is not about saying that Columbia can't build a campus in the project site area. The opposition in the community, by and large, has not been opposed to Columbia expanding. What the opposition is about, and what the case is about, is that it's not necessary or appropriate, it's not legal, it's not constitutional, we'll talk about that later, Ross, to use eminent domain here. Columbia can build, it's got 91% of the project site, and you don't get everything you want in this world.
Well, that's the final comment. I think that's a truism. I want to thank Ross Moskowitz and Norman Siegel. This has been a very stimulating debate. And I must say that I learned a lot from the presentations today. I hope that you did as well, in opening up an issue that is of very great importance to the city and to the state. As we always do at these breakfasts, we like to give to the featured speaker a product of the scholarship of New York Law School, and in appreciation to Norman, I'd like to give him a recent copy of the New York Law School Law Review devoted entirely to the Corporation Council and the history of it. And in particular, there's some discussions of some of your cases, which you might find very interesting. So thank you again, and we look forward to seeing you at our next breakfast.